Welcome to the New Books Network.
Hello and welcome to Madison's Notes, the official podcast of Princeton University's James Madison Program in American Ideals and Institutions. I'm your host, Laura Laurent, and on this week we are celebrating Constitution Day in a two-part series. The first episode, we have the pleasure of speaking with Cass R. Sunstein. He's a professor at Harvard and founder and director of the program on behavioral economics and public policy at Harvard Law School. In 2018, he received the Holberg Prize from the government of Norway, sometimes described as the equivalent of the Nobel Prize for law and the humanities. In 2020, the World Health Organization appointed him as chair of its Technical Advisory Group on Behavioural Insights and Sciences for Health. From 2009 to 2012, he was administrator of the White House Office of Information and Regulatory Affairs. And after that, he served as the President's Review Board on Intelligence and Communications Technologies. Mr. Sunstein has testified before congressional committees on many subjects, and he has advised officials at the United Nations, the European Commission, the World Bank, and many nations on issues of law and public policy. He serves as an advisor to the Behavioural Insights Team in the United Kingdom. Author to hundreds of articles and dozens of books, he most recently had one published titled Campus Free Speech, a pocket-sized guide, which was released only on September 3rd, 2024. In this episode, we're going to discuss origins of his newest book and details of First Amendment applications on college campuses. We get into constitutional interpretive styles, which one or ones Sunstein himself sees as a viable option, and challenges in regulatory measures in times of administrative crisis. So stay tuned for this conversation because I promise it isn't one you're going to want to miss. Professor Sunstein, thank you so much for coming on to Madison's Notes this afternoon.
Thank you so much. An honor to be here.
Yeah, it's quite exciting. You are giving the Constitution Day lecture at the University of Princeton, so we get to have this conversation in lieu of Constitution Day and hopefully releasing around that time. You recently came out with your new book, Campus Free Speech. It really came out like 3 or 4 days ago, so congratulations. And my first question that I wanted to get a little bit of background as to why did you feel the need or necessity to release this book in our present moment?
Well, it has a very specific origin during the disputes in the spring where people were struggling over free speech on campus. I started writing notes to myself about scenarios involving certain kinds of actions by students and faculty member and how under First Amendment principles they'd be resolved. And I didn't know whether I'd publish it, but the notes to myself kept getting longer and longer. And eventually I had something like a short book, and I sent it to Harvard Press, which said they liked the idea of doing this as a book, and they gave me an absurdly short deadline to get a book in shape. And they said if I could meet that deadline, they would, with an absurd amount of speed, they would get the book out in September. And I said, I like that challenge. And so I got going on it, and they got it out on September 3rd.
That's fantastic. And I think it's very apt because given all of the events on campuses this spring, I think a lot of people are looking at this new semester wondering what's going to happen, how are these issues going to be handled? And your book certainly gives numerous case studies and small examples of what the First Amendment how it would apply in different cases. And one of the first distinctions that you make that I think is really important and I found interesting was your distinction of First Amendment application to public versus private universities. Can you tell us a little bit more about how the First Amendment is applied in those two sort of subgroups?
Yeah, it's pretty straightforward. So the First Amendment applies to public officials. So if University of California at Berkeley or the University of Mississippi is restricting speech, we have First Amendment issue. Might come out favorably or unfavorably to the university, but First Amendment is in play. If it's Princeton or Harvard or Colgate, no First Amendment issue because the First Amendment applies to government. It doesn't apply to private entities. So if, for example, the New York Times decides it's only going to publish speech that has one point of view, the First Amendment doesn't kick in. And the same is true of the Wall Street Journal. So the First Amendment's application is restricted in that way. And that means that we have constitutional issues all over the place, but there are areas where we really don't have constitutional issues. One of my arguments is that the First Amendment should voluntarily be applied by private universities to themselves. So the First Amendment doesn't apply to private universities if, for example, Princeton or Colgate decides to restrict speech in certain ways. Completely permitted to do that. Now, it might be that a state law, and this is going to get a little abstruse, a state law applies the First Amendment to private educational institutions. California does that. But then what is binding the institutions is not the First Amendment, it's the state law, and that's extremely rare. So generally, private institutions, including universities and colleges, they don't have to worry about the First Amendment. I think they should voluntarily choose to worry a lot about the First Amendment. That is, in my view, and we can discuss this if you like, private universities would be well advised to follow the First Amendment, but that's not because they must, it's because they ought to.
Yeah. And I do want to dig in a little bit more into why they ought to, because it starts to come down to the purpose and the mission of the university space.
Yes, so let's start first with making life easier or hard. If a university says, let's say it's Princeton or Colgate, we're going to build up a system of restrictions and permissions on our own, life is going to be very difficult. There are going to be a lot of contests, and also it's just hard. The First Amendment creates a body of principles that has a lot of answers in it. And that's to suggest if you use the First Amendment as your basic framework or your complete framework, you will make life a lot easier for you, for yourself. The second point is that aside from being easier, it makes life better. So if a college or university adopts First Amendment principles as the foundation for how it's going to handle protests, it's going to have some really good principles. So the First Amendment, a lot of the cases are debated and the Supreme Court is divided, but over the course of centuries, the legal system has developed principles which, whether you're a Republican or a Democrat, whether you like blue or red, whether you're far right or far left, chances are you're going to like these. Chances aren't 100%, but chances are good you're going to like these. And the sense in the principles is, I think, pretty self-evident. If someone says, burn down this building with a crowd of 100 people right in front of the building with, let's say, equipment for starting a fire, that probably shouldn't be protected. But if someone says, I think that atheists can't be moral, or I think that religion is the opiate of the people, those are completely protected statements.
Mm-hmm. Mm-hmm. Yeah, and I can definitely see how trying to build your own framework complicates things. There's sort of a shared ethos of the First Amendment. It's something that, regardless of the quality of one's civic education, the general citizen will probably have some sort of understanding of it, and thus makes it's more communicable, maybe. And there's so many more resources built upon it. So I think that's an important point, that the ease and simplicity affects or impacts its effectiveness.
Well, it's a little like, the great philosopher Edmund Burke talked about traditions and longstanding practices with a kind of, I think for him, not just respect, but awe. And whether or not we are Burkeans, our First Amendment principles, as they've been developed by a lot of diverse and wise people over time, I think it deserves respect. And I'd even go so far as to say it deserves awe, that it makes the kinds of distinctions that on reflection we probably want to make, that if someone makes a direct threat against someone, if I see you in this classroom again, I'm going to hit you in the nose. That's not protected free speech. If someone says, say a professor says, if you want to get a good grade, you better go on a date with me. That's not protected by the First Amendment. But if someone says something like Israel should never have been created, or capitalism is racism, those are things that don't fall within a category of regulable speech, and go for it.
Mm-hmm. And although the First Amendment, using it as a framework, regardless of if you're a public or a private university, there still can be a lot of contention around what free speech means and when it's appropriate. Do you feel as though or are you aware of why it is still something that is difficult for us to understand in our current American political landscape? Like, what is it making it so contentious?
Okay, I'd want to underline as the kind of headline that the First Amendment makes most questions easy. It really does. So if you're a university administrator and you commit yourself to following the First Amendment, most of life is going to be easy. If students shout down a speaker, there's no First Amendment right to shout down a speaker. If students take over property that's not theirs, there's no First Amendment right to trespass. If you build tents on a place where tents aren't welcome, the First Amendment doesn't protect tent making. Now, if generally tents are welcome and certain kinds of tents are allowed, but others aren't allowed because of the point of view they express, then we have a First Amendment problem. That's clear. Viewpoint discrimination is strongly presumed to be illicit. So let's underline and shout from the rafters the fact that the First Amendment makes most questions easy. The vast majority become easy. The cases we saw on university campuses in the spring, the bulk of them, we have something close to a rule book that handles the bulk of them. Now, let's talk about some that are hard. If a professor says in class, let's say, that men do a lot better in my class than women do, or let's say a dean dean of admissions makes a sexually explicit video, those are not cases where the First Amendment provides a kind of rule book answer. And the reason it's hard is a university can say our educational mission requires something, like our deans of admissions to be able to be deans of admissions, or our professors to be teaching students with a commitment to learning on the part of everyone who enrolls. And if a teacher makes, let's say, a deeply sexist comment about who can do well in his class, it might be the teacher just can't perform well. Or if a dean of admissions makes a sexually explicit video, to be dean of admissions, given that, might be, challenging. And so some of the hard cases, people can even dispute whether those are hard cases. Maybe they're easy. But the cases where the university says its educational mission calls for certain restrictions on speech. And that can be a good faith argument that can allow an educational institution, public one literally bound by the First Amendment, private one aspiring to be bound to the First Amendment, to run into reasonable disagreement. Just like a public employer, let's say a government, can say to be employed here, you can't be engaged in certain forms of speech. In fact, there's a law called the Hatch Act, which restricts political activity on the part of government employees, and it's widely regarded as constitutional. The reason is public employees are supposed to be working for the people, and to confound the political action with public service is maybe leads to corruption of one kind or another. That's thought to be okay. And for educators, professors, administrators, or students, to be required, let's say, to treat one another with respect, that's probably okay. We need to specify what respect means, even though for the government to say that everyone has to treat everyone else with respect would run into serious constitutional problems. Disrespectful speech, saying about science or about politicians, they're full of nonsense, might not be respectful, but what the Supreme Court has called uninhibited, robust, and wide open speech is what the First Amendment authorizes. Uninhibited, robust, and wide open. I think that's fair on university campuses, but there are limits to, let's say, how uninhibited professors and students are allowed to be. And that's okay. And then we can dispute what that concretely means.
Mm-hmm. I have one question that's a little bit more detailed, and it's a little bit, it goes back to the private versus public universities, but are private universities still not under the First Amendment, even if they might be receiving some sort of federal grant or aid? If there's a research center on campus, that are they still not, um, they're still not held to the same laws and regulations, even if they're receiving care from or receiving support from the federal government?
Completely right. So the receipt of federal funds doesn't make you into what's called a state actor for First Amendment purposes. There's a law called Title VI, which kicks in for recipients of federal funds. And Title VI has certain anti-discrimination provisions that kick in. But even those are subject to First Amendment constraint insofar as we're talking about private institutions. Those don't make the First Amendment apply. Now, we could imagine some exotic cases, I guess, if you had a center which receives all its money from the government. Is it therefore a government center? Uh, then there might be a technical question. But the mere receipt of federal funds as such does not make an institution a state actor.
Okay, understandable. I'm curious, you have extensive experience in legal expertise, and you're teaching in law school, so you're constantly engaging in environments that are usually much more used to disagreement and argumentation. And I'm curious, what are some of the virtues that other students or other players might not receive if they're not in the same environment that you're in regards to engaging in free speech?
Well, when a law school's working well, uh, there's going to be a lot of different views on the table, and people will learn first that there are a lot of different views out there, and that people who are in important respects like them think very differently from how they do. And that's really important. So to learn that your fellow students think, for example, that some point of view that you regard as absurd is actually true, that's learning. Um, so if you're in a classroom and you hear people saying things that you think are absurd or uh, illogical or evil, in a law school, one of the virtues of that is you learn what other people think. And even if you don't learn that there's anything good to be said for it, it's important to know what other people think. And for a university to be focused on one point of view as if that's the only point of view is inconsistent with learning. The other thing is that I've seen time and again that students will eventually be moved by a point of view that they initially regard as terrible. So they might think, affirmative action is great. And then they'll hear a bunch of things and they might think, well, affirmative action is just good. Or they might think affirmative action is bad. They'll shift their views. And it can work the opposite way also. And that process of learning shows a kind of humility about the necessary truth of what one thinks today. And also, you can forge a consensus maybe on something where previously you showed great divergence in views among people who thought the alternative view was nonsense. That's kind of a model for how science works. It's a model for how democracy works. And that's one reason why diverse positions at law schools are completely essential to the production of good lawyers.
Mm, mhm. And so something that I'm really interested about in your career path is your work in behavioral behavioral sciences. And this might be a bit of a stretch, but is there a connection between the time that you've spent within the behavioral sciences and your viewpoints of free speech? Is there a connection there?
Well, there have been kind of different academic foci for me, but there is a relationship that the behavioral research focuses on ways that human beings depart from perfect rationality. So it's sometimes said the behavioral work suggests that people are irrational. I think that's best avoided, as do most behavioral types. But sometimes we think we have information that we lack. Sometimes we use heuristics or rules of thumb that can get us in big trouble. Like we might judge probability by thinking, does an example come readily to mind? And then we can get really scared about something that isn't dangerous or really complacent and something that is worrisome. We might be focused on today and tomorrow and not the long term. That's called present bias. We might be unrealistically optimistic. That's called optimistic bias. We might show a failure of attention to all features of a situation. Uh, Limited attention is very important. Our reasoning might be motivated, meaning we believe as we do, not because we have grounds for the belief, but because we have a strong desire for the belief. And these are well-established findings in behavioral science, and they kind of hammer home the importance of a system of open, free expression, because you need that to overcome your own, let's say, imperfections as a reasoning creature.
Mm. Yes, absolutely. And something that's coming up for me is noticing the respect component in that, um, having a basis of respect, a basis of coming in good faith, is also offering a bit of an olive branch to yourself in saying, I might learn something and I might actually become like one of these, what I view as opponents at this moment. Insofar as, well, I should respect them because one day it might be me having that position, if we feel flexible enough to have our minds changed. Um,
Learnahan said, a great judge with an unusual name, Learnahan said in World War II, the spirit of liberty is that spirit which is not too sure that it is right. And that's a great phrase. Notice he didn't say the spirit of liberty is the spirit that is not sure that it is right. It's just not too sure that it's right.
yeah, we have an inclination. Yes, yeah, yeah. There's something dangerous about being very, very sure of oneself. But also to live in unsurety is kind of can be a scary place at times as well, in a world with incomplete information.
Aryan would be wrong. So I'm sure that dropped objects fall. I'm sure that pretty sure that I'm talking to a human being right now. I'm sure that the house in which I'm sitting is not going to collapse in the next half hour. The number of things that we're sure of is very high. Some of the things that we're sure of, we ought not to be sure of. But I say, as a first approximation, many of the things that we're sure of, we're right to be sure.
Mm-hmm. Yeah. That's a whole conversation I'd love to go down the rabbit hole on, but and I'd like to move into some constitutional interpretation, because that's one of also your specialties and your focuses. I'm curious, how does your view of the Constitution mainly differ from what we're seeing across the Supreme Court and different areas of legislation in the political environment, just to give our listeners a basis of your background?
Okay, so we need a little cast of characters, uh, to, and then I'll see which character I like best. So there are some people who believe that we follow the text of the Constitution. That's our focus. Um, Justice Scalia and Justice Thomas emphasize that. And many people in the political domain emphasize text, call them textualists. It's hard to find people who aren't textualists. So to say that I don't follow the text of the Constitution is a little bit of a surprising view. The challenge for people who are textualists and pound the table is the text is often indeterminate. So the First Amendment prevents Congress from enacting a law abridging the freedom of speech. You can be an English speaker and reader and not know what the freedom of speech includes. Does it include blasphemy? Does it include obscenity? Does it include libel? Does it include commercial fraud? Does it include criminal solicitation? Does it include perjury? So textualism, let's say, is a widely held view, but it is something that is easy to agree to and not going to have a lot of decisional authority. There are some people like Justice Breyer who are purposivists. They think that the Constitution has purposes, of which self-government is one, and the notion of the purpose of interpretation can give us a handle on how to deal with, let's say, a dispute over whether the First Amendment protects libelous speech. And a purposivist might be drawn to the view that certain kinds of libelous speech is protected because it's central to the process of self-government. Or you might think the Equal Protection Clause has a purpose, which was one of racial equality, and that purpose would be the source of interpretation. So Breyer is a purposivist. He's skeptical of the idea that textualism has authority. He also thinks in some cases textualism is wrong, but let's just say textualists and then purposivists. There's some people who believe that we should interpret the Constitution to make up for deficits in democracy. They believe that the idea of constitutionalism is closely associated with reinforcing the democratic process. Now, what does that mean? It means that the Supreme Court would take an aggressive approach if we have voting rights being jeopardized or if we have political groups that are marginalized at risk. So the democracy reinforcers, as they're sometimes called, would like Brown against Board of Education, outlawing school segregation, and they'd like the court's decisions calling for one person, one vote. And you can see them as you can see the democracy reinforcers as a different camp from the purposivists, or you can see them as making common cause with the purposivists. Then there are people who are originalists. They believe that the text should be understood to fit with its original public meaning. Typically, that's their view. So if the First Amendment's original public meaning allowed regulation of blasphemy, then we should allow regulation of blasphemy. If the Equal Protection Clause in its origins allowed school segregation, then we would allow school segregation. The purposivists don't like the originalists because they think that originalism has too cramped a view of the Constitution's reach. Originalists don't like purposivists because they think they're making it up and they're not sufficiently disciplined. Then there are people who are moral readers, that is, people who believe that we have general principles in the Constitutions, especially in the rights provisions, who should give the best imaginable moral reading to provisions. So the right of freedom of speech could be read in a broad way or a narrow way, and the moral readers believe that the choice between the broad and narrow reading depends on what morality requires, and the judges have to make that judgment. Originalists think that moral readers are arrogant and that they're authorizing judges to impose their own views of morality. Moral readers tend to think that they'll lead to a better system of constitutional law than originalists do, and they tend to insist that moral readings are going to happen anyway, so you might as well be honest about it. So we have the originalists, we have the purposivists, we have the textualists, we have the moral readers, we have the democracy reinforcers. That's basically the cast of characters we have. I tend to emphasize how we choose among them rather than which choice we should make. And I say that the only way to choose among them is to figure out what makes our constitutional order the best it can be. So if originalism produces a constitutional order we should be ashamed of, then we shouldn't be originalists. If moral readings lead to a constitutional order in which judges are imposing their own moral views on the rest of us, and the judges are imposing, let's say, terrible moral views, then we shouldn't be moral readers. And that my submission, I have a book with Princeton called How to Choose, How to Interpret the Constitution. It's really how to choose a theory of constitutional interpretation. Basically says the only game in town is what makes our constitutional order the best it can be. And I'm more emphatic about that than I am about what particular theory to choose. There's an imaginable world in which originalism is right, because it produces a better constitutional order than the alternative. I think ours is not that world that originalism would produce, to bring it home, a system of freedom of expression, which would be much less thrilling than the system of freedom of expression that we have. I tend to like a democracy reinforcing approach to constitutional law. That's my favorite. And that's because I think that leads to a constitutional order that we should all be uh, grateful to live in.
Mhm. I'm curious what you think some of the drawing points are if one is, say, an originalist. Like, why would you want to stay in that bucket and not necessarily use a myriad of the interpretive lenses?
So Justice Scalia, who's probably the leading originalist, was a colleague of mine at the University of Chicago and was a friend of mine for many years, and I admire him. I don't agree with him at all, but I admire him. His view is that if you're an originalist, then you're constrained. So you ask a historical question: what was the original meaning of the founding document? You don't ask a question that is looser. You don't ask a question that licenses you to impose your own moral convictions on the country. You say, I'm just a judge. I'm not a hero or a president. I'm supposed to follow the law. And if the original public meaning of, let's say, the Fourth Amendment on unreasonable searches and seizures is a certain, the original public meaning goes a certain way, then I should follow it, rather than just say, I think this is an unreasonable search and seizure. So his view is that the rule of law calls for originalism. And if you abandon originalism, you end up in a free-for-all in which unelected judges are making moral judgments which should be made by the people.
Mhm. I'm curious if we could use the Chevron case as an example here. How do you see these players coming together in that specific example of the changes of Supreme Court rulings in regards to the Chevron case?
So the Chevron case says that where Congress has enacted a law that's ambiguous, it might use a term like source, what does source mean exactly, or diagnosis, that in such cases the agency that's operating under the law gets to resolve the ambiguity so long as the resolution is reasonable. So Chevron says that courts won't make it up on their own. They will respect the view, let's say, of the Environmental Protection Agency or the Department of Transportation. Now, Justice Scalia actually was a prime celebrant of Chevron. He liked it for most of his career, started to dislike it, it appears, late in his career. The reason he liked it was he thought, okay, we don't have a clear statement from Congress about what the meaning is. Better someone who's politically accountable and technically expert resolving the ambiguity. And the best inference is that Congress wants that to happen, given that Congress asked the EPA or the Department of Transportation to act under the law. So the court's theory of Chevron is we don't know who Congress wanted to interpret the law. It's more reasonable to assume that if the agency has the power to make rules, let's say, that the agency gets to interpret the law, so long as the interpretation is reasonable and this law is ambiguous, than the court. Now, the court got dissatisfied with Chevron as the years went on, thinking that the role of the judiciary is to say what the law is, and Chevron transfers authority to interpret the law from the judiciary to the executive branch. And um, the skepticism, I think, was grounded fundamentally in suspicion of the administrative state. I think that's really what it's about, though there's some technical discussion to be had about whether Chevron is consistent with the words of the Administrative Procedure Act, which is the thing that is the kind of foundation of judicial review of agency action. So, broadly speaking, I think the debate over textualism, originalism, democracy reinforcing judicial review is a different debate than the debate over Chevron. The debate over Chevron is whether we best take congressional instructions as being, court, you figure out the law, or instead, court, defer to the agency interpretation of the law when the law is ambiguous and when the agency's interpretation is reasonable.
Mm. No, that's an important distinction to make. So thank you, because that was something that was percolating on my side. I'm curious, as another case study when looking at free speech specifically, in times of administrative crisis. Most recently, maybe the COVID time period. One can argue we're still in it or not, but when it comes to types of speech that are counter to the restrictions that maybe the administration is putting on social functions, etc., and the interchange of power dynamics in those situations.
Great question. Let's say people are getting sick a lot because of COVID. The free speech restrictions on government censorship don't loosen. So if people say the COVID problem is made up, or if they say that all you have to do is drink a lot of Diet Coke and you won't get COVID, or if they say the restrictions make no sense, or if they say that COVID isn't even a thing, that's all protected by the First Amendment. So we didn't see, as far as I'm aware, restrictions on speech. We saw restrictions, which people debate, but not restrictions on speech. And one reason is any such restrictions would be constitutionally very, very much in trouble. They'd be struck down in a hurry. A harder question would be, in wartime, what restrictions on speech would be acceptable? And there's a tradition, there's a book on this called Perilous Times by Jeffrey Stone, a great book that allows more restrictions on speech in wartime than elsewhere. And Stone basically deplores that. He says the psychology is clear, but the law in the relevant periods is something we feel ashamed of. I think he's broadly right. There's a test called the clear and present danger test. So if you are outside a building and say, storm the building, please, everyone, because the people in it are villains, that can be restricted. That's generally agreed. The clear and present danger test has been softened in cases of national security threats during the Cold War and during actual wars, where the danger was less clear and less present, and still the government said you can restrict it. And I think we should be vigilant against the risk of, let's say, excessive softening. though under conditions of, really extreme threat. Justice Jackson said the Constitution is not a suicide pact. So you could imagine cases where restrictions would be warranted, but I hope that's will always be an exercise of imagination.
Mm. Something I've always been curious about is the extension of power in times of crisis for war for example, and how if a nation was to restrict, or America was to restrict certain types of free speech in wartime, how do you see an effective retraction of that power post crisis? Because that seems to be the issue of a softening. Is it's softened once and then that becomes the new status quo until maybe it gets softened in the next crisis, et cetera. And do you see there being an appropriate way to retract something that was made in crisis to not become the new normal?
Well, we're talking about speech itself. In the U.S., the free speech culture is very strong right now. So we can say things about social media and some of the controversies over its engagement with social media. And those are interesting discussions to be had. But the idea of the government literally banning speech because, let's say, we're having trouble with China or Russia, that would be require a lot to change from how things are now. Uh, if it happened, we're really in counterfactual scenarios that's very hard to get at least I find it very hard to get my mind around. We would have to have a big switch in a bunch of things for there to be, let's say, regulation of speech that's pro China or pro Russia. And then if we had speech regulated of that kind in that way, I would not welcome those regulations, though I am very not pro China and pro Russia. Well to the Chinese people and the Russian people, of course, but their governments don't seem to me to be admirable in all respects, though yes, in some respects. So we would want to hope that any such restrictions, which are counterfactual and hard to imagine, would be loosened once the danger passed. And there's some support in American history for that some restrictions that were imposed during wartime, not recently, but during historically remote wars, are very far from part of the current fabric of our law and would widely be regarded as unconstitutional now.
Mm-hmm. Mm-hmm. Yes. I'm curious, do you see there being in all of your experience across so many different areas, something specific about free speech in America? Why is it such a potent characteristic of ours versus other Western nations? And is it simply the First Amendment, or yeah, can you speak to your viewpoint of why it's such a potent force for us?
Yes. So much of the time I live in Concord, Massachusetts, which is where the American Revolution started. And the American Revolution came from something called republicanism, small r, which is about self government and a belief that uh, people are equal in important fundamental ways. So the idea of a monarchy would be abhorrent. And if you come out of something like what happened in Concord in the early moments of the American Revolution, you might have a self understanding as a people that puts free speech first. Now, cultures like Germany and Ireland and France and Italy have their own commitments, and free speech is among them. But it has a kind of centrality to our origins that seems to resonate throughout the decades and centuries. The Civil War and the abolition of slavery, sometimes described as the Second American Revolution, that had an overlap with the first one, where the abolitionists required speech. That was the sine qua non of what led to uh, abolition. And so that resonates also for the right and the left right now in our country. Let's say the far right and the far left. Freedom of speech is, to a significant extent, we want to be careful, but to a significant extent, bedrock. Not in all corners. There are people on the left who want to censor speech, people on the right who want to do the same thing. But for many on the extremes, as much as you abhor your adversary, you will defend to the death with Patrick Henry their right to say what you deplore.
Mm. I think it brings out two really important notes for understanding our current political climate is one, just the historical context that we're living in and looking at how we're continuously shaped by the American process of development and how important that is. And then also, again, the commonality that we may have with others who we abhor or disagree with is so important continuously. So my last question for you is towards the Constitution, and why do you think the Constitution has been such a tenable document? Why has it been able to maintain and continue to be a part of these and be the bedrock for these very important conversations of government throughout time when many other states or nations' constitutions have not held up against the test of time? And do you think that the Constitution is going to be able to continue its role as we move forward as an American people?
There are two things about our Constitution that have led to its endurance. One is it's great. So they did a really, really good job. Not perfect by any means, but it's great. And the other is that it's flexible. So it's been taken to be flexible. So if it were in a mold that fit exactly with how it was understood, let's say 1792, I think it wouldn't have endured. But terms like executive power vested in a president of the United States, the freedom of speech, the grant of certain authorities to the judiciary, those things haven't been like straitjackets. They've been more like frameworks. And that has led to less need for change than we would otherwise have. The change, by the way, which has often been judicially ratified, and sometimes judicially engineered, is a product of interaction between the democratic process and the judiciary. So when the judges do something like require states to recognize same-sex marriage, which is certainly not the original understanding of any provision of the Constitution, it's recognizing what was about to be, or which kind of was, a social consensus.
Mm-hmm. No, well, and thank you so much for your time and your insight. I know you've got incredible experience across the board. So for our listeners, I highly encourage you to go and check out any of Professor Sunstein's works, as they are all going to be edifying regardless of the topic. So again, Professor Sunstein, thank you so much for coming on today's show, and we really appreciate you spending the time with us for this hour.
Thank you. A great honor to be here.
Thank you for tuning in on today's episode of Madison's Notes. Professor Sunstein's new book, Campus Free Speech, is available wherever books are sold and will offer you a pocket-sized guide to thinking about free speech on college campuses. Check out the show notes for additional publications of Professor Sunstein's. As always, you know where the buttons are to like and subscribe, so send this podcast to someone who, as Professor Sunstein says things that you abhor. I'm Laura Laurent, and this has been Madison's Notes.